Okay, I think we are getting everyone in line now. We have our counsel. I believe this is the case of Kelly and Trust Mortgage. Mr. Mandelbaum, I believe you represent the appellant and Mr. Esteves, the appellee. Is that correct?
Correct.
Okay. Mr. Mandelbaum, did you wish to reserve any time for rebuttal?
Yes, I'd like to do 12 and 8 for rebuttal.
Well, our maximum is 5.
Okay, then 15 and 5.
Okay. With that, we are ready to begin the argument on this case. Counsel, you may proceed.
Yes. Thank you, Your Honor. May it please the court. We represent appellant Kathy Kelly, who submitted an online auction bid in Lee County on March 19, 2018 to attempt to purchase a residential property in Lee County, Fort Myers. And she had noticed that the first mortgage holder, Nation Star, had its foreclosure action dismissed with prejudice and was found to be time barred. About 15 months earlier, before she put in her bid, Nation Star's dismissal from the appeal was dismissed as well. In the meantime, 7 other bidders, including the appellee twice, had submitted bids and won the property for purchase. However, all of them backed out. Most but one lost their deposits, and the one, a lawyer bidder, got his deposit back as well on a basis of mistake. Well, anyway, before that, appellant had requested that her bank, Bank of America, first wire a deposit sum to her, and then after that, to wire the purchase price for about $170,000 over to her bidder account. However, for the purchase money, it was sent directly to real auction and then on to a Lee County clerk. In the meantime, appellant got a tip from a realtor or someone to that effect that this was a bad, highly encumbered property. They noted that the first mortgage may still be alive. At that point, she immediately filed a motion to vacate within 2 days after that. In this appeal, she makes 2 challenges. She maintains that the foreclosure was marred by mistake, surprise, accident, inadequacy of consideration, and other equitable factors, and noted that this may have been tinged by fraud in that 7 bidders have pulled out, including the appellee. We base our argument primarily on the Arsali case out of the Supreme Court in 2013. And in that case, the Supreme Court noted on the question of gross inadequacy of consideration, surprise, mistake, accident imposed on a claimant, and irregularity in the conduct of the sale, the court is committed to the doctrine that a judicial sale may, on proper showing made, be vacated and set aside on any or all of these grounds. Well, anyway, when she filed her motion to set aside and vacate the sale, the judge denied it, relying on the caveat emptor doctrine and the order, which was drafted by appellee's counsel, basically was a long discussion on caveat emptor, and that was about it. And we believe that the caveat emptor doctrine is going by the wayside and is no longer given credence. In the meantime, in 2016, the Florida Supreme Court in the Bartram case created a new or modified rule that essentially creates roving limitation periods unbeknownst to the appellant. And Nation Star and now appellee essentially contend that Bartram effectively had resurrected Nation Star's foreclosure case that was previously dismissed with prejudice, or at least a part of it. And that was later dismissed by this court on stipulation. First of all, we believe that the Florida Supreme Court has decided to step away from, quote unquote, the arcane doctrine of caveat emptor, and that was noted by the Supreme Court in the Miranda Holmes versus Lakeview case, which we cited in our brief. We've also noted the case of U.S. Bank versus Vogel from 2014, the 4th District, which essentially supports our position. As a second ground, the appellant argues that she had directed her bank to wire her funds directly to her bidder account, and instead that was somehow sent directly to either Real Auction or the Lee County Clerk. But it got out of her hands just minutes before she learned of the serious problem that in fact had caused the 7 prior bidders apparently to back out, and most of them lost their deposits. In any event, the trial judge, by relying entirely on the caveat emptor doctrine, had essentially looked no further and didn't really follow the wisdom of the Supreme Court in our Sally or any of the similar cases. And from the grounds that have been described by the appellant, those grounds are certainly grounds to be considered by the court. And even a mistake is a ground. So if the plaintiff, whether she was a lawyer or not a lawyer, that should be a ground to seriously been considered by the court, as opposed to the blind following of the caveat emptor doctrine. What's surprising here is that sales by owners of property are subject to very strict limitations by principles of fraud and otherwise, that they have to make full and complete and truthful disclosures. However, when a bank forecloses on a property and then sells it, according to the trial judge's logic, the bank can conceal anything, can make any falsehoods or whatever, and be off the hook based on the caveat emptor doctrine. And that can cause a lot of damage to purchasers, and does, in fact. Well, in the meantime, I'll reserve the remainder of the time for my reply argument and let Appellee's counsel have his time.
Thank you, counsel. Your 5 minutes is reserved.
Good afternoon. My name is Matthew Estevez. I represent the appellee Trust Mortgage. Trust Mortgage had a second lien that it was foreclosed several times, a second mortgage, and its remedy under Florida law is when the borrower doesn't pay, gets to file a foreclosure action, and the clerk puts the property up for judicial sale, and the public has a chance to bid on it. The public has a chance to bid on it under the doctrine of caveat emptor. If counsel said that I didn't add much more, the judge didn't add much more than that, it's because there is not much more than that. The case law is crystal clear, including the case that the trial judge cited, which is a Rios case, which is also an opinion that Judge Black and Judge Kelly authored along with Judge Wallace. That's a 2005 case that talks about the very argument, shuts down the argument that the appellant is making here. In that case, in the Rios case, the party complained about certain fraud alleged dealing with disclosures about the condition of the property And it wasn't fair that the bidder didn't know about certain sinkholes that the property had. This panel, this DCA said, sorry, caveat emptor. That's the rule. If you get on the auction site and you don't know what you're doing, you're subject to your own due diligence. Furthermore, the record in this case at page 181 in the record, the trial court made specific findings of, or took judicial notice of the following. This is from the frequently asked questions of the bidder site that the bidder, Miss Kelly, not Judge Kelly, the appellant Kelly, would have had to sign into and acknowledge in order to make a bid. Does the foreclosure or tax deed sale erase all other liens on the property? No, explanation mark. There may still be other encumbrances, judgments, priority mortgages, taxes, or liens that survive the sale. The winning bidder takes title to the property subject to all defects, liens, encumbrances, and matters of which he or she has or could obtain knowledge. The clerk's office does not guarantee clean title and is not responsible for any encumbrances on the property purchased at the auction. The laws regarding foreclosure are extremely complicated. It is recommended that all bidders perform a title search and consult an attorney prior to placing a bid. Record 183. So here we have testimony in the record that the bidder actually did do due diligence, and she determined, based on her review of the record, of the public record, and of the case law as a non-lawyer, she determined that that Nation Star lien had been extinguished vis-a-vis the Bartram case in the Supreme, before the Bartram case in the Supreme Court. And because the case had been dismissed with prejudice, she would be able to bid on this second mortgage, and she would get the property free and clear of any encumbrances. Well, she, like many lawyers around the state, were wrong. That Bartram case settled the issue, and the subsequent cases interpreting Bartram settled it further, that a bank can come back several times even after it's lost this first foreclosure case. So she was wrong on the law. I cited some cases in my brief about when you're wrong about the law, the courts cannot rescue you for mistakes regarding the law. And the Arsali case, the Supreme Court case in 2013, which appellant correctly cites as the main case that the court should focus on, talks about mistake, but it doesn't talk about a bidder making a mistake on the law. That is not the type of mistake that we're contemplating. It does talk about certain mistakes related. For example, I think another case that the appellant cites is the Vogel case. And in that case, the foreclosure lawyer for the plaintiff didn't communicate properly with his client, and they were deprived of the ability to bid at the auction. And therefore, somebody picked up the property for a couple cents or a couple dollars. And the court in Vogel said that's something that's more akin to a process in the sale itself that has gone awry. Here we're talking about a mistake by the bidder. There are no cases cited in the brief, and there are no cases that I'm aware of that talks about a bidder making a mistake and that causing the bidder to be able to get out of the auction. And that's very simple for how dangerous from a policy standpoint that would be. Imagine the bitter excuses that would come forth if that were the standard. Well, I didn't know that the law was X and I didn't know the law was Y. Bidders could bid on a property and then submit an excuse to the courts, and then we would be litigating about whether that excuse by the bidder under a caveat emptor standard is valid or not.
Is the standard for our review to determine whether or not the appellant's proffered rationale is legally sufficient a one of equity? Foreclosures are in equity, is that correct?
Yes, sir, they are.
So then we would be looking at this with regards to an entitlement or lack of entitlement based on equitable concepts?
Yes, sir, you can, the trial court can consider equity within the context of caveat emptor.
And that would tell you, please be aware of what you're doing, right?
That's correct. Caveat emptor being buyer beware. and both from the case law and the things that you have to click through to do the bidding. So there's
In this
construction
context, it's actually buyer prepare.
That's right. Yes, exactly. And so the Arsali case does talk about that issue of equity, that courts have equity to look at sales and see, because it used to be that you could only, before Arsali, there was an argument that you could only undo a judicial sale if you alleged inadequate consideration. That had to be one of the elements. If there was mistake and there was all sorts of problems with the sale, as long as it's sold for a sufficient amount, no problem, we'll affirm that. Arsali opened the door for the court to be able to weigh equitable factors based on the circumstances in those cases, none of which involve bid or mistake. It involves mistakes related to the sale itself, something in the judicial sale going awry, miscommunication, etc.
So is there a nexus between the type of mistake that we are to look at based on the language of the opinions, that's something that's inherent in the sale process by the statute, as the statute defines the sale?
Yes, the statute that you're referring to is 45.0315, and that specifically outlines statutorily what are the factors that the judge can review in looking at a proper objection to sale. So the objection to sale here was timely done. It was a proper objection from that, procedurally it was proper. It wasn't outside the timeline. However, the judge looked at those factors, weighed them, and cited Rios as the controlling case law in the second DCA with really no counter case law. The appellant's counsel talked about the cases going away from caveat emptor, but the cases that he's citing do not deal with judicial sales, which is a very particular type of sale. He's talking about other real estate transactions where people are hiding defects in the property and acting in bad faith. That's not what we have here. We have a judicial court sanctioned sale that goes up, and the public has an opportunity to bid. Anybody now online, really anybody in the world can bid on a property in Lee County under these circumstances. So obviously we can't have a standard that allows, in this case, an unsophisticated party would have an advantage over a sophisticated party, because the unsophisticated party could say, well, I made a mistake on the law, I'm sorry, I won out. And then what about the other hundreds of bidders that would have bid and they didn't, and we have to redo the sale? In fact, that's probably one of the reasons why the sale got reset so many times, is because people were bidding, they realized the mistake they made, they didn't complete the sale, and they just lost their deposit, and that kept going over and over and over. And I think that concludes my thoughts on that. If you have any questions, I would be happy to answer them.
Doesn't appear any. Thank you, counsel.
Thank you.
Okay, let me clear this. Mr. Mandelbaum, you have your 5 minutes for rebuttal, sir.
Yes, thanks. What about inadequate consideration involving the property? Here, the appellant received a near worthless property and is at a consideration problem too. And our position is consideration goes both ways, both for purchase price as well as the value or lack of value of the property being sold. And in US Bank versus Rios, this case is a much different case than the matter at hand. In Rios, which appellee substantially relies upon and reiterates the rule of caveat emptor, it's not really congruous to this case. In Rios, the plaintiff made claims of fraud and fraudulent inducement as a grounds to set aside the foreclosure sale. According to the purchaser, he was unaware of any sinkholes existing on the property he purchased and filed a motion to set the property aside, which was granted by the trial court. However, there was abundant evidence there showing that the purchaser had been readily aware of the sinkholes on the property before he purchased it. And for that reason, this court reversed and directed that the motion to vacate be set aside. And that's probably a right decision. Here we don't have those circumstances, nor the equity considerations of the Rios case. The appellant also suggests that a bidder making any mistakes on the law is different than a bidder making mistakes on the facts. However, the record showed that the Nation Star foreclosure action was a dismissal with prejudice. So that's a pretty strong statement. And to most lawyers even, it means that it's a matter forever dismissed. It's over. And it's not a casual term to see. So, why someone like the appellant, who briefly worked in title searches, would look at a dismissal with prejudice any differently is not really a mistake on the law. At this point, we would ask that this court reverse the order denying the appellant's motion to dismiss and remand for further proceedings. At least on the issue of the improper wiring of funds, which went into the real auction account rather than directly into her bidder account. Thank you, and appreciate your time today.
Thank you. Thank you, Beth.
Okay.
Okay. That will conclude this argument. We will allow counsel to return to wherever we go electronically, we will await the next case.